Bam, welcome back. Did the Idaho court system deliver justice, or did it force a surrender? Today we pull back the curtain on the unseen pressures driving this case, from Gregory Rauch's calculated legal strike to the explosive secret plea pushes witnessed by Steve Goncalves. This is the record exposed. Part 1. The anatomy of the pivot. Before you can understand the recusal, you must understand the trap. 68 terabytes of unindexed data handled to the defense just weeks before a capital trial. That isn't discovery, that is a wall. When the court denied time to review it, a fair trial became a physical impossibility. This data wall didn't just stall the defense, it forced the Ann Taylor pivot. Under the Sixth Amendment of the U.S. Constitution and U.S. v. Cronic, a Supreme Court case, when the court creates conditions where no lawyer could reasonably prepare, prejudice is presumed. The choice to plead under these constraints wasn't strategy, it was structural duress. In just 14 days, the defense backed into a corner. Shift from trial prep to capital survival. When a system leaves a defendant with one hand tied behind their back, a signed deal isn't a free choice. It's a tactical surrender. Part 2. Rauch's strategic strike. The move that changes everything. Why did Gregory Rauch demand the raw audio of the July 2nd hearing? Because paper lies. Paper hides hesitations, pauses, and coached answers. Rauch isn't reading the transcript. He is hunting for the tone of coercion. Under Boykin v. Alabama, a plea must be voluntary. But a yes spoken under extreme duress sounds entirely different than a yes spoken in truth. Rauch is building a nonverbal record to prove a Hobson's choice. This is the domino effect. Step 1. Capture the raw audio. Step 2. Prove the colloquy failed constitutional standards. Step 3. Trigger the mandatory recusal of a judge who was never a neutral observer. Part 3. The Goncalves' revelation. The witness from inside the process. Steve Goncalves broke the silence. He revealed that Judge Hippler wasn't just sitting on the bench. He was actively brokering plea deals behind closed doors. The moment a judge becomes a plea negotiator, he ceases to be a neutral judge. Now, let's look at the record. Pushing an Alford plea skips the truth-finding mandate of Rule 11. Personal involvement in deal terms destroys separation of roles. The court was driving for finality at the direct expense of due process. Now it gets worse. Steve Goncalves alleged the judge threatened his family with sanctions for interfering with the resolution. Using the power of the bench to threaten families into silence is the ultimate red flag of judicial bias. In Steve's own words, he threatened us for interfering with a judicial proceeding. He was the one pushing the plea deal behind the scenes. Read that again and tell me this court remained impartial. Part 4. The judicial loop. The constitutional trap that requires recusal. Under the case in re Murchison, a judge cannot investigate the state's integrity on leaks while simultaneously brokering the state's plea deal. Wearing the investigator hat and the judge hat at the exact same time creates an unconstitutional loop. The law doesn't require us to prove subjective evil in the judge's heart. Under Caperton and Murchison, the standard is the objective risk of bias. An entangled judge cannot act as the gatekeeper over his own potential conflict. Recusal is mandatory. Prosecutor Bill Thompson openly stated an allocution was unnecessary because the defendant would lie, but Rule 11 requires a factual basis. If the state calls the speaker a liar, the legal basis for accepting his plea is completely undermined. Now let's look at the Gregory Rauch's roadmap. Disqualify the judge. Open discovery into the audio and chambers meetings. Void the plea for structural error and revert this case back to a fair trial-ready status with a neutral court. Accountability belongs to the people. In 48 hours, our verified petition for independent judicial review goes live. Scan the code, lock in your signature, and stand up for constitutional due process. Protect the Constitution.